Hi, good evening, friends. My name is Adv Ajay, and today I am here to resolve the few questions which has been raised by you in a different topics. And few most important questions were with respect to the jurisdiction, asserting the jurisdiction in the matrimonial dispute. So, how we are going to ascertain the jurisdiction with respect to a matrimonial issues. So basically, my friends, for a matrimonial issues or matrimonial discourses which are coming for the litigation, either in the form of domestic violence or either in the form of divorce, divorce in a uniform civil code or in a personal code. So either of the situation, you have a three important jurisdiction. One is known as the pecuniary jurisdiction, with respect to the residence of the party, means either of the spouse who are residing, or the place of marriage, or the place where you are presently or existingly residing. So either of the three will be the jurisdiction with respect to the matrimonial disputes. And the second important questions which was raised was related to the dispute in negotiable instrument act, whereby one of my concerned friend has asked कि Ajay, under the section 138 का whatever application we are filing, there is always a discrepancy with respect to the cross examination and the onus of the proof and the burden of the proof. Basically, I will always suggest कि in the matter of 138, that is negotiable instrument, the burden of proof never lies upon the complainant to show that this particular check or this particular instrument was issued for so and so purposes. The burden of the proof lies completely upon the defendant to state and establish the fact that this particular check or this particular instrument has not been issued with respect to this concerned transaction, or it has been issued with a purpose of collateral security or etc. But the entire burden of the proof is upon the other party, not on the complainant. So my friend, always be very much definite with respect to the burden of proof and the onus of proof. And the third important question which was brought before me was from the commercial suit with respect to the specific performance of a particular contract. My friend, my concern with respect to your question was very precise. Then whenever we are talking about the commercial suit, the higher purpose of the commercial suit is not about the specific performance but about the recovery of the money. My friend, there might be a chances that commercial suit can be filed for the specific performance also, but the specific performance, if we are talking about, it is completely going to cover under the breach of the contract. Okay, and specific performance has to be ascertained by the court by performing, and there is no monetary valuation which can be ascertained unless and until the performance is not been committed to be complied. So my friends, basically you will have a liberty to file a civil suit for a specific performance, or either you can file a commercial suit for damage and compensation. If you are seeking for a damages and compensation, definitely the commercial suit is going to be a very appropriate course of action. Now the fourth question which was raised to me was it was related to the domestic violence. In this question was that if the party, if the accused and if the respondent is not paying the money even after the distress warrant has been issued. My dear friends, if the distress warrant has already been issued against the party for the n number of default, and even then also if he is not making the remittance of the payment, so I will suggest you can file execution application for the original order of the distress warrant, or second you can do is that to file an application under section 20 or 20 sub clause 6, which direct the magistrate to recover the money directly from the employer, and you have nothing to do in between. The court will order, and the employer of that particular person will directly deduct the money and will remit it to your particular account or to the court. Thank you.